I'm John Hanson, the managing attorney of the American Law Firm, and what you're about to view is a short video on frequently asked questions about contesting a will. Now, contesting a will is a complex process that can often result in protracted litigation if done without the proper legal assistance. So if you or anyone you know is wanting to know more about contesting a will or about estate planning or probate law in general, call the American Law Firm today at 815-394-1776 for a free consultation. Our attorneys have decades of experience that can help you navigate through the options available to you to reach your goals. There are a few common scenarios where contesting a will can occur. Now, the first scenario is when a person wants to assert that when the will was made, the person the will was made for did not have the mental or physical capacities to understand what was going on. For example, if an elderly parent creates a will when she or he has already been diagnosed with dementia or Alzheimer's, then another family member could contest the validity of the will, since it's possible the parent could not have realized what she was doing or what he was doing at the time they created the will. Another common scenario is when a spouse has been left out of a will completely by the other spouse. In that situation, the spouse who's left out can seek to have the will voided by a court. Also, you sometimes see assertions made that when the person who made the will had it done, they were being forced by another party to put certain provisions in the will that they would not have done normally. A person able to contest a will must have an interest that could be affected by the will as it stands, meaning the person who stands to benefit financially or who already has an interest in the property may be affected. Those people have standing. Examples of such people would be children of the person who made the will, spouses of the person, as we talked about above. It is a difficult task to have a will rendered invalid by a court, except when it's a spouse who's electing to void the will. Now, Illinois law provides that a spouse can automatically elect to take 1/2 of the entire estate of the deceased spouse if the deceased left no descendants, regardless of what the will says. If the spouse left descendants, then the spouse that's surviving can elect to take 1/3 of the estate. Now, other than that scenario, for a court to render a will invalid, the person contesting the will would have to prove that undue influence, incapacity, or forgery and fraud were present when the will was made. Now, once the burden is met to prove that any of the above claims exist, then the burden shifts to the person who allegedly committed those acts or created those issues to prove that the will was not the result of wrongdoing. And when we talk about capacity, we're talking about the mental ability for a person to know and comprehend their financial and family situation, essentially. Now, this is best determined by a physician, and that can either be the person's regular physician or, even better, a neurologist or a psychiatrist. Now, sometimes it will be advisable to have an opinion obtained in writing from a physician before the will is even drawn up. The writing would prove the person has capacity and would put that issue to rest. Now, in addition, testimony from persons who knew the person who made the will and testimony from an attorney who prepared the will can also be used to prove capacity. By getting a will done as soon as possible, and by getting a physician's opinion, you can avoid most contested will situations. If you or anyone you know needs a will or other estate planning document, contact the American Law Firm today to get a free consultation scheduled on this area. Also, check out our videos on our website for more estate planning information. Contesting a will is difficult because the burden is hard to meet in most cases and it's hard to prove in court. The sooner you see an attorney on this time-sensitive topic, the better your chances will be, whether it's to contest a will or to make sure your will is created while you have capacity. Call our office today at 815-394-1776 for a free consultation to discuss your particular legal issues with our attorneys.